Hello and welcome to Constitutional Cappuccino, the wake-up call to the Constitution and the ideals it espouses. My name is Frank Caprio. I'm going to be your host. Just a little programming note. As I was going over my earlier podcasts, I realized that slowly but surely I was making them really, really long. In excess of 20 minutes, I have a couple that are between 25 and 30 minutes. That's just too long. So what I'm going to be doing from here on out, unless it's a special occasion, is to keep it to 7 to 10 minutes. Specific topic, really explore that topic, and then wrap it up. Make it very user-friendly so it's much easier for people to actually sit down and listen to the thoughts so they can get a good idea of what I'm talking about. And with that being said, today's topic, the Supreme Court. Lots of misconceptions about the Supreme Court. I'm here to clear some of those up. It was never the intention of our founders to leave justice to judges. It was never intended that judges rule on cases of the people. They were there to simply preside over court cases to make sure the proceedings were fair, that everything was covered, any evidence, all the machinations of a court trial. That is exactly what a judge is, to make sure everything is done correctly. This is supported by the Constitution. Article 3, Section 2. Article 3 deals with the Supreme Court, and in Section 2 it reads, "The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes have been committed." Even with that in the Constitution, again, let's remember that the Constitution was passed without a Bill of Rights. There were a lot of people that were concerned that some of our common law practices would not be carried over. They would be forgotten in the new document or maybe excluded because they weren't listed. So that's why we got the 6th and the 7th Amendment. The 6th Amendment, impartiality, states, "In all criminal prosecutions, the accuser shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein this crime shall have been committed." And the 7th Amendment reads, "In all suits at common law, where the value and controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of common law." So basically, any time there's an infraction of the law by an American citizen, you have the right to a trial by jury. You're not supposed to be going in front of judges for them to tell you how long you're in jail or whether you're guilty or not. And that goes into one of the powers of the people, and that's the power of the jury. That's going to be a different podcast, though, because we're going to keep this focused on the Supreme Court. So, according to the Constitution, up to this point, we have established that in any case, in civil cases over $20, you have a right to trial by jury. So where does the Supreme Court fit into all this? The Supreme Court issues opinions. Those opinions are just that. They're opinions. They're not laws. They're not mandates. They're not regulations. They're opinions, which advises the American people that it is their belief that if you perform a certain activity, then you're either constitutional or unconstitutional, depending on what the opinion states. That's all it is. It is a guiding post for the American people on how they should, proceed with their lives. It doesn't tell them that they have to do it that way, but it does say that if you go to trial or if you go to court over an issue and you're on this specific side of it, it is our opinion that you're either in unconstitutional or constitutional territory. That's it. That is the extent of the powers that the Supreme Court have directly over the people, which is absolutely zero. And we need to get back to that. Nowadays, what we have are interpretations of interpretations, which have gotten so far away from the original meaning of the Constitution that they're useless. And they just need to be ignored. When the First Amendment states that we have a right to peaceably assemble. We have a right that our free speech shall not be infringed, that the right of the press shall not be infringed, the right to keep and bear arms shall not be infringed. And when a law is passed that does exactly that infringement that they are not supposed to, it doesn't matter what the opinion of the Supreme Court is. It's the opinion of the American people. They're the ones that are going to be filling the jury boxes, and if they feel that the law is unconstitutional, that's one of the checks and balances in our society. It's the same way. I mean, I've already talked about this on a previous podcast, but look at the 18th Amendment, prohibition. In no small part, that was taken away because juries just stopped convicting in a lot of areas. They just said no. And without those convictions, then nobody was going to jail. The government started looking like really asinine, and powerless. It was actually showing the power of the people, and they couldn't have that. So then we got the 21st Amendment eventually, which is the only amendment that ever rescinded a previous amendment. That was the power of the juries, and that's what we need to get back to. And just to let you know, the idea of judicial activism is not a new one. Thomas Jefferson was a big proponent of. I mean, he didn't like the courts. He didn't like the federal courts, and he made some comments on it. One of his more popular quotes is, and I quote, "To consider the judges as the ultimate arbiters of all constitutional questions is a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Our judges are as honest as other men and not more so. They have with others the same passion for party, for power, and the privilege of their core. And their power is more dangerous as they are in office for life and not responsible, as the other functionaries are, to the elective control. The Constitution has erected no such tribunal, knowing that to whatever hands confided with the corruption of time and party, its members will become despots." Sounds kind of familiar. James Madison also weighed in, and he stated, quote, "The states, then, being the parties to the constitutional compact, and in their sovereign capacity, it follows of necessity that there can be no tribunal above their authority to decide in the last resort, whether the compact made by them be violated, and consequently that as the parties to it, they must themselves decide in the last resort such questions as may be of sufficient magnitude to require their interposition." So to boil that all down, the Supreme Court is the creation of the Constitution. There was no Supreme Court before the states ratified the Constitution, which created our federal government, of which the Supreme Court was 1/3 of. And if you believe they are the final arbiters, then you believe in being ruled, not governed. What is the limits to the power of the federal government if the document that circumscribes their power is interpreted under their discretion? None is the correct answer, and that is exactly what we're seeing today. The supreme power in our republic is the states. It is easy to demonstrate that this is true. Who are the only entities in our country that can change the Constitution? Imagine, if you would, that the House of Representatives voted unanimously, the Senate voted unanimously, and the President signed an amendment to the Constitution, and the SCOTUS said that it was constitutional. Would you consider that lawful? Of course not. Article 5 describes the only way that our Constitution can be amended. Only the states can change the Constitution. And it is time for those states to perform their function of protecting their citizens' rights and nullifying these unconstitutional edicts coming out of the Supreme Court. Jefferson and Madison agree. Nullification and interposition is the path to liberty when the federal government is working outside of the boundaries of the Constitution. Remember, to secure these rights, governments are instituted among men, deriving their just power from the consent of the governed. And we are seeing it. Slowly but surely, the states are standing up to some of the unconstitutional activities of the feds. Let's support that. This has been Constitutional Cappuccino, the wake-up call to the Constitution and the ideals it espouses. I'll leave you with a quote from Thomas Jefferson. "Rightful liberty is unobstructed action according to our will within limits drawn around us by the equal rights of others. I do not add within the limits of the law, because law is often but the tyrant's will, and always so when it violates the rights of the individual."